Hello and welcome to another edition of the Peninsula Biz Buzz. My name is Shelley Smith, here representing my company Premier Rapport, and also the Chamber Liaison for the Penn Sherm chapter. Bob, over to you today.
Hey there, Bob McKenna from the Virginia Peninsula Chamber of Commerce, President and CEO. And today on Peninsula Biz Buzz, we have Tom Lucas from Jackson Lewis law firm down on the south side in Norfolk, I guess, right, Luke?
That's right. Yeah, my office is, one of the 61 offices our firm has nationwide. In Virginia, we have 3 offices, one in Richmond, one in Northern Virginia, which is, called our DC area office or whatever, then our office in Norfolk. And of course, you all know us for being, active throughout the peninsula and with Peninsula Sherm.
Okay, Luke, so let's dive right in here. 6 or 7 weeks ago, when we were being told that COVID-19 didn't present a great risk to the United States people, what was the mission of Jackson Lewis then, and what in particular was your job and your role in that firm?
I'm the managing partner of the office, managing shareholder of the office here in Norfolk. Our firm is, as both of you I believe know, is a boutique to the extent that we do nothing but labor and employment defense work for corporate clients nationwide. So this week, 61 offices with 950 lawyers or whatever, but our mission, frankly, has always been to cover the breadth of labor and employment, human resource issues for our corporate clients, which of course is in our various 17 or so practice groups includes a disability and discrimination practice group, which is now featured prominently in terms of servicing clients as the COVID-19 virus has become such a omnipresent threat. And so what's not changed for us is that we've historically been involved in counseling clients daily, in addition to representing them in litigation in the area having to do with the Americans with Disabilities Act, both in terms of public accommodations, but also in private workforce issues. That's expanded to with the blossoming of this epidemic has been a huge need to help clients work through issues of employee dislocation. So we've been counseling at a very high level, very high quantity or volume with clients over the last 3 or 4 weeks who are faced with, unfortunately, workforce reductions, which have become sort of massive nationally, but also in Virginia as well, and counseling employers through the need for WARN Act notices, and also to help them, sort through the legal options having to do with potential furloughs, RIFs, and/or mass closings. Those have been the issues which have been primarily our focus, but also, of course, with everyone learning as we go, about how the FFCRA, the Families First Coronavirus Response Act, which is composed of 2 different acts, both the Paid Sick Leave Act and the Emergency Family Medical Leave Extension Act. Those have been implementing those, complying with those have been the sort of the challenge that all our clients, employers everywhere, and certainly throughout Virginia, have been faced with, and that's what we've been largely focused on, it seems, in addition to the usual caseload.
So suffice it to say that you guys are very busy right now.
We are. We've really been swamped, and I think it's true probably of every law firm that services employers.
Right.
Helping clients work through those issues.
Yeah. So, okay. So busy through the response. You're going to keep focused on those types of things. I've started to recently, in the last couple of weeks, and with the talk of opening up America again. I've been looking at the checklist. I've been looking at the 3-phase plan. I've been looking at the templates for reopening, and most people don't really consider the legal aspect of it. The legal aspect of it is overwhelming in my mind. Can you comment on that? Can you comment on how do we move forward from a legal perspective? And what are your concerns?
Well, the principal concerns, of course, are the ability to, operationally, to be able to safely incorporate employees back into the workplace. Now, frankly, for many employers that have manufacturing facilities or port operations, for example, here in Norfolk and there, never really ceased operating. And so those employers, of course, have had the challenge of trying to work safely, incorporate some of the, the CDC and government's guidelines about how to keep their workforce safe. But it's those safety and disability issues, frankly, which will be primary, in the forefront as employers reopen, to the extent they haven't been open already. So those will be the challenges. Legally, the points of sensitivity are going to be the potential interplay between, some of the requirements of reopening and possible monitoring and testing of employees, or having to take adjustments in the workplace that could conflict in some way with the Americans with Disabilities Act. So that will be the primary sensitivity for employers, that is making sure that whatever policies they implement, whatever manners in which they become operational again, that they don't do anything which could be potentially a violation of the ADA. It's the number one area, I would think.
Can you give me an example of like a potential violation of the ADA?
Well, the ADA generally, the Americans with Disabilities Act, passed 1990 and amended 1991, makes it unlawful for an employer to discriminate in any way against employee or applicants or employees, but employees in this case, what we're talking about in the workplace with respect to a physical or mental condition which affects major life activities like their ability to work. That part of the issue under the ADA is the extent to which employers can inquire about the nature or extent of a disability. So some of the sensitivity there would be, as employees come back in the workforce and they potentially either have a test positive or whatever, or have exposure to those who are testing positive. There's some sensitivity about the extent to which an employer is going to be able to inquire about that condition, and also the extent to which they may be forced to quarantine, for 14 days or more, whatever. The issue that relates to that is, of course, employees who may be exposed to someone who tested positive. Now, frankly, the guidance that's come from the Department of Labor with respect to the implementation of the FFCRA suggests that the employer, any employer, is going to be privileged to inquire about someone's condition if they test positive, require that they report it so that they can safeguard their workforce. But that's going to be part of the sensitive sensitivity as workforces gear up again. Now, frankly, many of us, or many employers, of course, have been working throughout this period, I think, and have been dealing with those issues day to day anyway. And I think successfully. For example, we certainly have not heard from any clients that there have been assertions, claims or assertions that employees' privacy rights or rights under the ADA have been violated. So hopefully that will continue.
So, okay, so that gives me some optimism that maybe opening up America is not going to be as huge a problem as I was thinking, because you're right. I mean, a lot of employers already have their employees working. So how about the hospitality industry, like hotels, the airline industry, and other small businesses? That's, I guess, going to be the main focus area, right?
You mean to the extent they have a greater potential for exposure?
Greater exposure, but also they haven't really been working. I mean, they've been kind of shut down. So now they're going to be returning to work, vice continuing work like a lot of the rest of us.
Well, I think you're right. The extent there's a greater potential for exposure, then those issues, claims, could be more prevalent, but hopefully not.
Good. Okay. Shelley, over to you.
Tom, a few questions around any recommendations or advice or resources you can give on handbook updates from a policy, procedure, suggested approach, or resources that you guys have already put out there, you found as best practices?
Yes, Michelle. I think the principal issue that as the Paycheck Protection Act and other statutes or the other provisions of the extended FMLA and paid sick leave have been implemented, from the FFCRA. I think the area that could create confusion and questions for employers to have to work through their employees have to do with the interplay between existing paid leave policies and the additional leave policies, that are provided by the FFCRA. The Department of Labor's Q&A in that, frankly, does a very good job of setting forth the interplay there. I'm sure most employers have been through all that. There are dozens, literally, of Q&A in the DOL's guidance on that. But I think any employer who has worked through those issues, and I'm sure most have, will find it beneficial to review their current handbook leave policies, paid leave policies, and square them up with the requirements of the statute. Now, admittedly, the statute's only going to be on the books, it seems, for the end of 2020. We'll see. Now, the other interesting, and Shelley, I think you and I may have chatted about this, new statute is the potential interplay with a Virginia statute, which is passed by the General Assembly. The General Assembly this year did a number of things in the employment law arena. One of the things they did was to renew a portion of the statute having to do with unemployment benefits. Senate Bill 548, which has not quite been signed into law yet by the governor, but has undergone a little bit of revision. But in a nutshell, it's a portion of the unemployment insurance provision of the state code that provided for work sharing arrangement between employers and their employees. Now that policy or that statute existed prior to 2016, but really sort of fell into disuse for lack of funding, apparently, but was revived in this session of the General Assembly. And in a nutshell, what it provides, like many other states, frankly, currently have, is that employers may request approval from the Unemployment Commission, Virginia Unemployment Commission, for policy of work sharing, and that rather than riffing or laying off employees, engaging or imposing a furlough somewhere between 10 and 60%. And if the employer does that, it does it pursuant to an approved plan approved by the VEC, then the currently available stimulus money, which includes up to additional $600 per week for employees, can be received by employees. So it's possible, for example, if the statute is signed into law soon, and effective apparently July 1st, hopefully, that an employer could furlough its employees, say 1 or 2 days a week, somewhere between 10% and 60% a week. The employee, under this, as I understand the statute, that's going to be the way it should operate, is the employee would then be able to get no 7-day wait period for receiving unemployment benefits, but could receive that stimulus money, the Paycheck Protection Act, additional $600 per week on top of that prorated unemployment, which would be a boon for employees, savings for employers, and so it's frankly a very nice possibility for employers who, frankly, perhaps otherwise might engage in RIFs or terminations, but in lieu of that, furlough some of their employees, cut their wage bill, frankly, give employees a little bit of time off, but also make them at least whole, and perhaps even better than that. Now, the problem with that is the statute apparently, if signed soon, would be effective July 1st, and that stimulus money, the additional $600 at the moment, I think is scheduled to run out at the end of July. But it would be fortuitous if, in fact, the federal government extended that. It would be something that Virginia employers could utilize.
It definitely would be a good thing because it gives a better win across the board for everybody. Because one of the things I know I'm hearing is that in some cases the employee is better off by doing the unemployment and the additional $600. So this brings back a win. So kind of to put a wrap and close on this, I know, Bob, you probably have a final question, but Tom, is there any particular other place other than the DOL website or something on your website for frequently asked questions or tips or resources that people listening that really need to go to that might help even field some of the calls you're getting?
Yeah, our COVID-19 resource team, which is composed of about 40 or 50 of our attorneys nationwide, posts any number of things daily, updates on any developments on any of these statutes, and anybody is can log into our website and tap into that anytime they like. So we literally have daily updates. And also the Department of Labor Q&A, that's about 75 questions and answers, is also very enlightening on all these issues.
Great, thank you. Bob, over to you for final questions or comments.
And did I miss it, or what's that website, Tom, Luke?
The DOL website?
No, yours.
No, yours.
Your company.
Oh, ours is www.jaxlewis.com.
Okay, great. Okay, last question before we wrap it up. I see that you're in your office, it looks like, not at home.
Yes, I am, yeah.
So, and I know Shelley's in her home office, and I'm in a corner of my bedroom sitting in an easy chair. What has your staff done to protect the workers? I'm assuming it's not business as usual. So have the work schedules been adjusted, or some of you working from home? How's that going?
The vast majority of our attorneys and staff have been working from home. Our firm implemented that fully 4 weeks ago in a number of the hotspots around the country, because we're nationwide, and certainly New York, Chicago, San Francisco, Los Angeles, and so forth, Seattle. All those places began working from home well over a month ago, I would say. More recently, we've had work from home policy, remote work policy throughout the firm, and virtually all of our staff and attorneys are working remotely. Frankly, I'm working in and out of the office, in lieu of traveling to clients, doing most of my work from here, but some from home, and we're having our staff here just sporadically, just enough to, they're also set up to work from home. So everybody's got the equipment and the ability to work remotely, and that's pretty much what we've done. We will probably continue to do that. Frankly, I would think for the foreseeable future.
So that's several of the podcasts that we've done. I've mentioned short-term transformations and long-term transformations, and I think everybody in the short term is trying to work from home as much as possible. But that's going to lead to a long-term transformation where employers, employees are more comfortable with teleworking. So we'll see. Yeah,
very much like our Zoom event here. Frankly, this week we completed some union negotiations where both our clients team and myself were all remote, but patched in through Zoom. The unions committee likewise were all remote. And we've been doing any number of mediations with the EEOC and some with the Department of Labor for pending matters remotely by Zoom as well. So teleconferences, frankly, I would think would be a feature of our workplace. It's probably not going to go away.
Yeah, exactly.
Definitely saves time.
All right. Well, that's all we got.
Right.
Luke, I really appreciate you taking time from I know it's a very busy schedule to talk with us for a little bit today. And that's all I got. Until the next Peninsula Biz Buzz, I'll talk to you all later. And Shelley, thanks again.
Thank you very much, everybody. Have a good day.
All right, take care.